And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone. You're young.
Right from the opening seconds, the tone of this case is intense. Judge Boyd wastes zero time sugarcoating reality, and whether you agree with her delivery or not, the message is unmistakable. Prison is not just about serving time, it's about survival. And for someone young like Isaac Chavez, the risks go far beyond locked doors and lost freedom. So here's what we're dealing with. A young defendant already facing serious drug charges, now standing at a crossroads where one wrong decision could permanently redirect his life. The court isn't just deciding punishment, it's deciding whether this young man still deserves another chance outside prison walls. And pay attention to how the judge frames the stakes. This isn't just about possession charges or paperwork violations, it's about patterns of behavior. Courts look at patterns. Slip once, maybe forgivable. Slip repeatedly, that's when patience starts running thin. Over the next few minutes, you'll see the system working through procedure, discovery confirmations, plea agreements, waivers, all the technical steps. But beneath that legal routine is a very human story. Youth, bad decisions, second chances, and the consequences of not taking them seriously.
You know, and I'm telling you truth. You're going to be sold for a pack of cigarettes or some extra dessert.
Court is calling
That's what happens at the prison
2024 CR 1943, State of Texas versus Isaac Chavez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Doug Campbell for Mr. Chavez.
All right. Are you Mr. Chavez?
Yes, ma'am.
All right. Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Chavez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney?
Yes,
Did
ma'am.
you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication in the DOEP course. Did you understand that to be the plea?
Yes, ma'am.
Showing you outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 120 hours community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit 1 all happens.
No objection.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
This moment is legally huge, even if it sounds routine. The judge is saying there is enough evidence to convict Isaac right now. But instead of locking in that conviction, she's granting deferred adjudication. Here's what that means in simple terms. The court is giving him a pause button instead of a permanent record. If he successfully completes probation, the conviction never formally lands. But if he messes up, the court can immediately sentence him on the original charge, up to 20 years in prison. No second trial required. So deferred adjudication isn't freedom, it's conditional freedom. And those conditions are strict. Drug tests, community service, evaluations, employment requirements, and constant reporting. Missteps, and the court comes back into your life very quickly. Notice also how defense counsel highlights Isaac's youth and the fact that he was shot after this incident, trying to show hardship and growth. That's a common mitigation strategy. Present the defendant as someone who's already suffered consequences and learned lessons. But here's the key question for viewers. Do you think courts should give young offenders multiple chances to fix their lives? Or should consequences become harsher after the first mistake? What would you do if you were the judge?
Anything you wish to say on behalf of your client?
Yes, Judge. Isaac was 18 years old when this incident occurred. He's now 20 years old. I think he's wiser for the events that happened. As the court probably saw, he was shot twice because of this. He was almost at the end of his deferred, or is at the end of his deferred, that we're going to hear in just a moment. And he would like to do the TAP evaluation out in the world. He almost, but for this incident, was successful in completing that deferred adjudication.
All right, who is Dynasty Chavez
That's my cousin.
and how old is she?
Now she's 18, I believe.
And who is Roxanne Chavez
That's Dynasty's mother, Matia.
and how old is she?
Can't tell you for sure. Maybe early 30s.
Do you have any children?
No,
Okay, that's a good thing. How far did you go in school?
I graduated high school.
So what are you doing with your life other than picking up felonies?
As of right now, I was just working at Willie's, a restaurant. I was a server. I was
Okay,
just working where I can. With the felony, it doesn't really allow me to do much.
I'm sorry.
With the felony, it doesn't really allow me to do much. So I just work where I can.
Well, it sounds like you need to try to go to a trade school and do something else. I've had clients before who have been welders and they've had felonies. You just have to let them know up front what your charges are and how you've changed, if you have changed. If you haven't changed, of course, nobody's going to take a chance on you. You understand?
Yes, ma'am.
All right. This is what the court will do. There's a $500 fine. That would be probated. There's to be no contact.
Now we're watching the judge move into sentencing conditions, and this is where probation becomes real life, not just courtroom talk. Every requirement the judge lists becomes a legal obligation, and failing any one of them can trigger a motion to revoke probation. Notice how Judge Boyd pivots from punishment to life advice. She's not just assigning penalties, she's trying to redirect Isaac's future. Trade school, welding, plumbing, licensing, these aren't random suggestions. Courts see thousands of young defendants cycle through the system, and judges often know exactly what paths statistically lead away from repeat crime. And listen closely. She isn't disrespecting restaurant work, but she's pushing him to think bigger. Because probation is temporary, but career choices shape everything afterward. Stable employment is one of the biggest predictors of whether someone reoffends. This is actually one of the more human parts of courtroom proceedings. Judges sometimes become reluctant mentors, trying to give defendants the advice they wish someone had given earlier. But advice only works if it's followed. And as we'll soon discover, the real question isn't whether Isaac heard the judge, it's whether he listened. Because the next phase of this case reveals that compliance didn't go as smoothly as hoped.
With Dynasty. And that's spelled like the television show. Chavez. Or Roxanne Chavez. Who do you live with?
My grandfather,
What's his name?
Alfred Chavez.
I'm sorry.
Alfred Chavez.
All right, and where are your parents?
My mom, she's here in the courtroom with me right now, but I don't know who my dad is.
Okay. Where's your mom? All right. All right, thank you. There's the regular reporting by Zoom or in person. There's to be regular random UAs. 4 years deferred adjudication. 120 hours of community service restitution. That will be deemed completed if you obtain a certificate, get in someone's trade school. It's okay to work at Wendy's. We need people to work at Wendy's, but if that's what you want to do with the Willie's, all right.
Not fast food, regular restaurant.
All right, thank you. If that's what you want to do, working at Willie's, that's fine. We need people to work at restaurants. But if you want to do something other than your life than work there, or you have dreams about doing other things, you probably need to go to a trade school, or either you can go to college.
This section may feel repetitive, but legally and psychologically it matters. Judges often repeat instructions intentionally because probation success depends on clarity. If conditions are misunderstood, defendants later argue confusion, and courts want a clear record showing expectations were spelled out. Notice the range of requirements stacking up: community service, evaluations, sobriety meetings, employment proof, home checks, restricted living arrangements. Probation isn't just stay out of trouble. It's structured supervision designed to rebuild habits. And here's where many young defendants struggle. They underestimate how demanding probation really is. Missing meetings, failing to submit documents, or skipping classes may seem minor, but legally they count as violations. And the judge even throws in humor, joking about fast food work, which lightens the tone but reinforces a point. If you want more options, you have to build qualifications. The problem? Compliance requires discipline. And discipline is exactly what courts suspect Isaac may still be lacking. And soon we'll see why, because his probation record starts raising serious red flags.
Once you complete that, your community service hours will be deemed satisfied, or you can do community service hours. It's completely up to you. I would recommend, though, that you go to a trade school, become a plumber. Even though that requires a license, you'll just need to tell them about your history and tell them how you improved, and maybe they'll give you your license. You understand?
Yes, ma'am.
There's to be field visits one time per month for 4 months. How long will a tap in custody take? How long out of custody? All right. What drugs have you been using in the past?
In the past, I was using marijuana and Xanax.
All right. So we'll do a referral to felony drug court. That'll happen while he's in custody. Since today is Monday, they'll get to you before the week is out. If he's not accepted into felony drug court, then we can do the TAP evaluation out of custody. And what I'll do then is 60 sober meetings in 60 days. And probation, if you could keep track and make sure that if he's not accepted in felony drug court, they take care of the TAP evaluation. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. With regards to your grandfather, who all lives with him?
Oh, it's just me, him, and my brother.
All right. And how old is your brother?
He's 18 now.
All right. He is to reside with his grandfather, Alfred Chavez. You're not allowed to leave that residence and reside somewhere else without the court's permission. Do you understand?
Yes, ma'am.
If you leave that residence and reside somewhere else without the court's permission, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
Probation, they want the DOEP course. That course is don't use drugs. It fries your brain. But I'm still going to give it to you because obviously you need it, okay?
Yes, ma'am.
Probation, is there anything else he needs?
Okay.
All right, is there anything else you need from the court to be successful on this probation? All right, we can go off the record. Here's the thing. In order to be successful on this probation, because you're on probation here. You got to communicate and stay in contact with.
This moment feels almost informal, but it's actually critical. The judge is stepping off pure procedure and speaking directly about survival on probation. Communication, honesty, and proactive problem solving. Those are the survival tools she's emphasizing. Probation officers aren't just rule enforcers, they're gatekeepers. If someone struggles but stays honest, officers sometimes work with them. But if someone disappears, avoids contact, or ignores instructions, officers assume the worst and recommend revocation. And now comes an important turning point. We learn Isaac has another probation case being terminated unsatisfactorily. That's a massive warning sign. When courts see multiple supervision failures, patience wears thin. Let's pause here and ask something important. If someone keeps getting chances but continues slipping, at what point does accountability outweigh second chances? Should courts prioritize rehabilitation, or does public safety come first? Because what's coming next is where the situation shifts from hopeful probation to potential disaster. And police testimony is about to change everything.
People. So if there's an issue, let probation know. If you feel as though probation is not addressing it, you can always come back to the court, okay?
Yes, ma'am.
All right, and I'm sorry, back on the record in that cause number, this is run concurrent with 2022 CR 1798. All right, court is calling 2022 CR 1798. Are you proceeding with the motion to revoke?
Yes, Your Honor, he was gonna be turned on Saturday.
All right. Probation, is that your recommendation to terminate him unsatisfactorily? All right, on that probation, then you will be terminated unsatisfactorily. All right.
Yes, ma'am.
All right, thank you. 24 CR 1943, State of Texas versus Isaac Chavez. Can I have parties announced for the record for the state? Defense?
Doug Campbell for the defense, ready.
And are you Isaac Chavez?
Yes, ma'am.
Are you the same Isaac Chavez who was placed on deferred adjudication in 2024 CR 1943 for the offense of possession of a controlled substance penalty group 2, 4 to 200 grams on April 15, 2024 for a period of 4?
Now the atmosphere changes completely. We're no longer discussing opportunities, we're discussing alleged violations. And violations are serious because deferred adjudication is hanging over Isaac's head. When someone is accused of breaking probation rules, the court examines each alleged violation individually. Alcohol use, employment proof, education program attendance, evading arrest, and more. Even if only some allegations are proven, probation can still be revoked. The strategy here is interesting. Defense counsel tries to challenge parts of the accusations, while the state stacks evidence showing repeated noncompliance. Courts don't need proof beyond a reasonable doubt like a criminal trial, just enough evidence to believe conditions were broken. So the stakes are enormous. One wrong ruling here, and Isaac could go from supervised freedom straight into prison time based on the original drug case. And just wait, because the testimony coming next paints a chaotic picture involving intoxication and a traffic stop that escalated quickly.
4 years, is that you?
Yes, ma'am.
State?
On or about the 22nd day of June 2024 in Bear County, Texas, the defendant Isaac Chavez committed the offense of evading arrest or detention of the vehicle in violation of condition number 1. Your Honor, do you want me to read all of these and then allow Mr. Chavez to give his plea in
All right.
total or each one individually?
All right. Let me ask Mr. Chavez, with regards to the alleged violations of conditions, there's a violation of condition number 1, 2, 8A, 14C, 14Z, and number 34. Are you pleading true or not true to those allegations?
Not true.
To all of the allegations within the motion?
Yes, Your Honor.
All right. Then the defendant is pleading true to violations 1, 2, 8A, 14C, 14Z, and 34. All right, state, do you have witnesses?
Yes, Your
All right, state, you can call your first witness.
Honor. Equals Angeline Nicholas.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Angeline Nicholas,
All right, state.
Ms. Nicholas, how are you currently employed?
with Bear County Adult Probation.
And what do you do with Bear County Adult Probation?
Supervise, cases,
I'm sorry, you're gonna have to keep your voice up so the court reporter can hear.
sorry. I supervise cases, make sure that they're following the conditions. And
There is a microphone in front of you. If you would put it up using the microphone so the reporter can hear you.
sorry,
Do you supervise a person named Isaac Chavez?
I do.
Now, On June 22nd of 2024, did Mr. Chavez make an admission to you regarding his use of alcohol?
On June 24th of 2024, that's when I met with him, but he did admit that it happened on June 22nd, yes.
And when you say it happened, you mean that he consumed alcohol?
Yes.
Now, Mr. Chavez had a number of conditions of his supervision. Among them was to complete one AA meeting per day for 60 days.
Yes.
According to your supervision of Mr. Chavez, how many AA meetings per day did he complete?
It was more so one per week.
And how many in total?
8.
Did Mr. Chavez provide proof of employment or SSI within 30 days of his release?
No.
Has he provided any proof of employment?
No.
Did he register for or attend a drug offender education program?
No, no verification has been provided.
Now, did you give him a referral for a drug offender education program?
Yes.
Did he provide any documentation that he registered for it or attended?
No.
Any further questions?
Oh, Your Honor.
All right, thank you. State, call your next witness.
He calls Officer Ramos.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
I recently got married, so technically my name is Brianna Gonzalez.
I object.
All
Yeah, so
right.
I know my name still says I just got married on the 9th, so
right, congratulations.
thank you.
All right, state.
How are you currently employed?
I'm employed as a police officer with the Leon Valley Police Department.
On June 22nd, 2024, at approximately 7 a.m., were you dispatched to a particular incident?
I observed a car on Huebner Road, just on the street. The light was green, but the car was parked, or it seemed to be parked. I don't know if the driver's foot was on the brake or if it was in park, but they were stalled in the middle of the road as if they were parked.
Here's where things get dramatic. The officer describes finding a vehicle stopped in an intersection, an immediate public safety concern, followed by what appears to be an attempted traffic stop and eventual flight. From law enforcement's perspective, this looks like evading arrest combined with possible intoxication. And that combination is deadly in court. Judges take impaired driving extremely seriously because it risks innocent lives. Notice the detail. Officers activate lights, attempt contact, and the vehicle moves away multiple times. Even if the defense later argues confusion or delayed awareness, courts often interpret repeated failure to stop as intentional evasion. And then come the physical observations: alcohol odor, inconsistent statements about drinking, red eyes, even soiling himself. All signs officers associate with intoxication. While blood test results weren't available yet, behavior evidence still carries weight. At this point, Isaac's probation hangs by a thread. The judge must now weigh violations, credibility, and risk to the public, and the final decision could send this young man straight to prison or give him one last shot. And what happens next will determine whether this story ends in redemption or incarceration.
Can you briefly describe this vehicle?
The vehicle was a Lexus, 4-door vehicle.
So, upon seeing this vehicle, what did you do?
Well, because of the notes in the system, I activated my red and blue lights and I got behind the vehicle to initiate a traffic stop.
Did you get out of the vehicle, out of your vehicle?
I did not get out of my vehicle at that time, no.
And what reaction, if any, did the operator of that Lexus have to you activating your patrol vehicle's emergency overhead lights?
Initially, the operator of that vehicle did nothing. When my partner got out of the car, along with another officer that also pulled up to that traffic stop, they both got out of the car. I was about to get out of the car, but then the vehicle suddenly drove forward and it stopped in the middle of the intersection of Huebner and Bandera Road.
What happened next?
What happened after that is we all got back in our vehicles. We both got closer to the vehicle. Then we tried to get out again. I stayed in my car at that point. I didn't get out. And again, the two officers, the one in my vehicle and the other officer, got out to try to make contact with that person again, and that vehicle fled and evaded. So at that point, I told dispatch that I had a vehicle evading arrest.
And at that point, what did you do?
At that point, dispatch asked if I was in pursuit. I said no. So I was still behind the stopping point for that road. So I abided traffic laws and I waited for that light to turn green. That way I could turn.
Now, a short while later, did another officer communicate to you that they had detained the vehicle?
It wasn't communicated, it was observed. Because I could see it. It wasn't very far at all.
Okay. Was this vehicle the same vehicle that you earlier observed and that sped away from you?
Yes.
What did you do upon relocating?
Upon relocating to that vehicle?
Yes.
Oh, well, again, my lights were already off. So all I did was, as soon as the light turned green, I turned left onto Bandera Road and I got next to because my other officer, he had initiated a second traffic stop. He initiated his red and blue lights again on the same vehicle, and I stopped with that officer to try to initiate contact again.
And did you initiate contact with the operator of the vehicle?
Yes, eventually, because again, the other officer made that second traffic stop technically, and then we took him into custody at that point.
Did you identify the operator of that vehicle?
Yes.
How did you identify?
We asked him for his name eventually.
And what did he say?
He said his name was Isaac Chavez. He appeared to be intoxicated.
Did you observe the odor of alcohol emitting from his breath?
Yes.
Did he admit to consuming alcohol?
Yes.
How much alcohol did he claim that he had consumed?
Initially, he claimed that he only had one drink, but upon further questioning, I asked him, okay, what did you drink? And he said he drank Modelo and Smirnoff, so it didn't make any sense.
Did you make any other observations about his physical appearance?
Yes,
What observations were those?
he appeared to have urinated on himself.
Is that the only other observation that you made about his physical appearance?
Other than his glossy red eyes, he appeared to have soiled himself and the odor of alcohol on his breath. No, that was about it.
At that point, what did you do?
We formally told him he was under arrest for evading and DWI, and we read him his rights, and from there we transported him back to our police department.
This is the moment where the situation officially shifts from suspicious behavior to criminal consequences. Once the officer states that Isaac is under arrest for evading and DWI, the legal stakes skyrocket. On probation, even an arrest, before conviction, can trigger violation proceedings, and that's exactly what we're watching unfold. What hurts Isaac most here isn't just alleged intoxication, it's the perception of reckless decision-making while already under court supervision. Courts expect probationers to be extra cautious, not less. Every action is viewed through the lens of, did this person learn from their previous mistake? And the optics here are rough. Stalled vehicle, inconsistent alcohol explanation, physical signs of intoxication, and attempted departure from officers. Even if some details remain debatable, now as the narrative strongly suggests risky behavior. Think about this. Probation is essentially borrowed trust. And incidents like this make judges feel that trust may have been misplaced. Let me ask you, if someone already got a second chance and still ends up in this situation, should courts give yet another opportunity? Or is it time for consequences to hit harder? Because from here on, Isaac's fate rests on whether the court believes this was a momentary lapse, or proof that probation isn't working.
Thank you. Pass the witness.
Officer, would you agree with me that all things in life are a matter of perspective?
Not all things.
How can you be sure that Mr. Chavez saw the lights when you were behind him?
How can I be sure?
Mhm.
I mean, he's not legally blind as far as I know, so they're really hard to miss. So I can't be sure, but any reasonable person, even intoxicated, could have seen those lights.
And he pulled over immediately when the other car stopped him, right?
Well, he was actually already stopped at the red light, so he didn't technically pull over, but he didn't make any further attempts to flee at that point.
Right, and I guess that's my point. If he was just, based on what you're saying, he was asleep in the intersection, right? If he's just waking up, we're not sure he even knew you were there, right?
His eyes were open when I saw him.
Did he recognize you? Can you say that he recognized you?
I could say that he could have recognized a police officer in a police car with their lights on, yes.
Should have, but there's a chance that he didn't, right?
I'm sure, yes, there's a chance.
And during your interactions with Isaac, was he cooperative for the most part?
For the most part, yes.
And he courteous
For the most part, yes.
and compliant? Once he was stopped, right?
Completely compliant, but the other questions.
And you don't know what his blood alcohol level was because you don't have the labs back yet, do you?
Well, he didn't consent to blood, actually. He initially did and then didn't. But he had a blood draw, so no, I don't know what those results are.
So you can't say with certainty that he was intoxicated.
No, I can't.
Thank you, I'll pass.
Thank you.
Thank you.
State, any other witnesses?
That's all, Your Honor.
I'll call Isaac Chavez.
All right, Isaac Chavez. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Isaac Chavez.
All right, defense.
Thank you. Isaac, we've already identified you as the same guy who's on deferred adjudication for.
Defense counsel does exactly what good defense attorneys do here: introduce reasonable doubt about intent. The argument isn't necessarily that Isaac behaved perfectly, but that confusion, sleepiness, or intoxication could explain delayed reactions rather than intentional evasion. And legally, intent matters. Evading arrest requires knowingly fleeing law enforcement. If the defense can convince the judge that Isaac didn't recognize the police presence immediately, that weakens the allegation significantly. Notice also how the officer admits uncertainty. She can't guarantee he saw the lights. She believes he should have, but belief isn't proof. That nuance matters in court. At the same time, viewers should notice something important. Compliance after being stopped doesn't erase earlier behavior. Courts often ask, why didn't he stop sooner, even if cooperation eventually occurs? This moment shows the legal chess match unfolding, each side trying to shape how the judge interprets events. And the next testimony gives Isaac a chance to tell his own story, which sometimes helps and sometimes backfires.
Possession case, right?
Yes, sir.
Can you tell the court what was going on June 22nd of this year?
The day I was
Yeah.
stopped. Oh yes, I was at a friend's house. It was just supposed to be a normal hangout, but he ended up inviting other friends. I do admit that I did have alcohol, but I was peer pressured. I was trying not to at first, but just to fit in, I fed in.
Now, just to be clear, you're 20 years old, right?
19 at the time.
19, okay. And despite all of that, you understand that it's illegal for you to drink alcohol when you're under 21 in the state of Texas, right?
Yes, sir.
And despite all of that, you told your probation officer that you were drinking, right?
Yes, sir.
And did you see the police officer who was behind you in the intersection over in Leon Valley?
Not the person.
If you did, what would have happened?
I would have pulled over immediately.
And that you didn't try to run off when the second officer stopped you, right?
No.
I'm gonna ask you a question. I told you I needed you to think about this. Why do you think the court should continue you on deferred adjudication?
Now we finally hear directly from Isaac, and this is one of the most critical moments in any probation hearing. Judges pay close attention to how defendants explain their actions. Accountability matters. Excuses don't usually land well. Isaac admits drinking and frames it as peer pressure. That explanation is human, relatable even, but courts expect probationers to resist exactly that kind of pressure. Once you're under supervision, the expectation is that you avoid risky environments entirely. What helps Isaac slightly is his acknowledgement of mistakes and discussion of family responsibilities. Judges often consider whether someone contributes positively outside their criminal conduct. Still, sincerity is hard to measure, and courts see many defendants promise change only to reappear months later. Another issue surfaces: proof of AA attendance. Isaac claims compliance, but without documentation readily available, his credibility takes a hit in real time. In court, evidence beats memory every time. And now comes a pivotal decision point, where options shift from revocation towards structured intervention, something that could save Isaac from prison if handled correctly.
Truthfully, it's just I do acknowledge that I made a mistake. I acknowledge that I was irresponsible. But truthfully, for the past 3 years, I've been completely sober. I've been working honest jobs, helping with my family, my grandfather. Honestly, I was on the straight road. I was doing everything right. I don't believe.
Let's focus on some of the other violations that they've alleged. You've already told the judge that you admitted to drinking, that you did drink. Why didn't you ever provide any proof of where you were living to your probation officer?
I didn't necessarily know how. I told her where I lived and I had my ID. I didn't really know what more proof was needed.
And the 8603 Cape Valley address is on your ID?
Yes.
And they looked at that every time you went in, right?
Yes.
So you felt like you complied there?
Yes.
There's another allegation that you failed to go to Alcoholics Anonymous every day for 60 days. Did you understand that that was one of the requirements of your community supervision?
I did.
Why didn't you go every day?
I did actually go every day. I have the proof in my cell phone. I have the email sent to my probation officer. I have about 56 of them of every day that I went.
So do you take issue with the fact that she only testified that you went once a week?
I do, yes.
What did you learn, if anything, at the Alcoholics Anonymous meetings?
So let me just stop you. Where is the proof of this?
Judge, I don't have it. It's in his cell phone. I can't.
Oh, where's the cell phone? Did anybody look through his cell phone?
I did not, because I asked him to print them.
All right, you all want to step back and state, you can look through his cell phone and see if there's actually documentation that he did it. And I'm sure if he did it and it's proof there, maybe the state will waive the.
Well, it's just one, Judge. I got other ones I still got to address.
I know, but step back, let's see if he actually did that.
Two options.
Mhm.
And I think my client would like to take the local ISF,
Okay,
if that's an option.
all right, we're back on the record. And cause number 2024 CR 1943, state waive 14C without objection. Court is finding violations of condition number 2, the consumption of alcohol true. 14C, state waived it. 34, the court will find true. 14Z, the court will find true. 8A, the court will find true. Number 1, evading arrest or detention, the court will find true. Number 1, driving while intoxicated, the court will find not true.
Here's the legal bottom line. Several violations are officially found true. Alcohol consumption, failure to comply with conditions, evading arrest. These are not minor technicalities. Each one alone could justify revoking probation. But notice something important. The court finds the DWI allegation not true. That's a huge difference. Driving while intoxicated carries severe consequences, and removing that from the equation significantly softens the case against Isaac. Still, enough violations remain to justify punishment. The judge now faces a balancing act. Protect public safety while still allowing rehabilitation if possible. Courts constantly wrestle with this tension. Revocation would send Isaac directly into sentencing on his original felony. Instead, the judge considers alternative sanctions, structured treatment, monitoring, and stricter oversight. This is where judicial discretion becomes incredibly powerful. Two judges could look at the same facts and reach completely different outcomes. And now we see what Judge Boyd ultimately decides, and whether Isaac's final chance remains intact.
All right, probation, my understanding in this case, you're not recommending revocation? Oh, I'm sorry, they are recommending revocation. All right. All right, this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include probation. Since I'm denying the motion, do you recommend local ISF or state ISF? Because it appears we have alcohol issues as well.
Judge, so I did speak to defense counsel and I talked about ISF that is just going to address cognitive. However, if you do send him to state ISF, that you could order him to the substance abuse cognitive track. Obviously, there's differences in the wait time in custody for both facilities. So that is something I think defense was going to address.
Well,
Somehow,
sometimes that's punishment.
fair enough.
All right, so it's going to be state ISF. And there's to be partial GPS for employment only.
This ruling is tough but strategic. Instead of prison, the judge orders placement in state ISF, an intermediate sanction facility. Think of it as a structured correctional program focused on behavior correction, substance abuse treatment, and cognitive training. It's still custody. It's still restrictive. But it's designed to rehabilitate rather than simply punish. Combined with GPS monitoring afterward, the court is clearly saying, we're not done trying to help you, but we're watching closely now. GPS monitoring means movement is tracked, and violations become easier to detect. Employment-only movement restrictions further tighten supervision. Freedom shrinks significantly. This decision shows Judge Boyd believes Isaac still has potential, but needs a serious wake-up call. It's a final warning wrapped in structured support. And then comes the most memorable part of this entire hearing. The judge's blunt, almost chilling explanation of what prison life could look like if Isaac ends up back in court again.
Upon release. And I'll ask that GPS fees be waived. Probation, is there anything else?
Judge, is that going to be through the jail?
Yes.
Thank you. I think that'll be it.
All right, all other conditions will remain.
Oh, Judge, I'm sorry. Is that substance abuse cognitive track?
Yes. All right, anything else?
No, Judge.
All right, we can go off the record. You had better start doing better. Otherwise, you're going to prison. And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone.
Judge Boyd's closing warning is raw, uncomfortable, and unforgettable. Some viewers may find her words harsh, but from the bench, this is sometimes called shock therapy. Judges occasionally use blunt realism to make defendants fully grasp the risks ahead. Her message is simple. Prison isn't just boring or inconvenient. It can be dangerous, especially for young inmates. Vulnerability, exploitation, violence, these are real concerns courts recognize. Notice how she connects Isaac's current attitude to survival behind bars. Confidence or indifference in court doesn't translate well inside prison walls. She's trying to shake him into awareness before consequences become irreversible. And honestly, moments like this stick with defendants long after hearings end. Many former inmates say warnings like these echo in their heads when facing bad choices later. So now the question shifts away from court decisions and onto Isaac himself. Will this finally be the turning point? Or will we see him back in this courtroom facing harsher consequences next time?
You're young, you know, and I'm telling you truth. You're going to be sold for a pack of cigarettes or some extra dessert. That's what happens at the prison sometime. And this persona that you're giving me now, that's not going to help you at the prison. And maybe people will start fighting with you.
Maybe sometimes somebody at the prison be like, I don't feel like fighting with him today. They may say, yeah, I feel like fighting with him today. And that's what you're going to be doing. And the fact that you're young and you're doing dumb stuff is not going to help you at the prison. Do you understand?
Let's step back and look at the full picture. Isaac Chavez entered court facing serious drug charges and received deferred adjudication, essentially a second chance to avoid a permanent conviction. But probation demands discipline, and violations soon followed. Alcohol use, compliance issues, and a troubling police encounter. Despite strong grounds for revocation, Judge Boyd chose a middle path. Instead of sending Isaac directly to prison, she imposed state YSF treatment and stricter monitoring, a last structured opportunity to correct his path. This case highlights the constant tension in the justice system, punishment versus rehabilitation. Courts must protect society while also recognizing that young offenders sometimes deserve room to grow. But opportunities are not endless. Eventually, accountability catches up. The real ending to this story hasn't happened yet. It depends entirely on what Isaac does next. Will this intervention change his future, or will repeated mistakes close the door permanently? And that's where we turn it over to you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.